the final case, which is Alpha Eta Chapter of Pi Kappa, Alpha Fraternity versus University of Florida.
Thank you, Your Honor. May it please the Court, I'm Alan Windsor here on behalf of the appellant, and I'd like to reserve 3 minutes for rebuttal if I could. For more than 100 years, this chapter of the Pi Kappa Alpha Fraternity has been affiliated with the University of Florida. That affiliation came to an abrupt end in the fall of 2006 when the university's Office of Student Affairs suspended the university's official recognition of the chapter. That suspension continues today, and it will continue for years to come, absent some relief from this court. The suspension began as an interim one following a weekend barbecue in October of 2006, and it was an interim suspension continued pending the final hearing, which was conducted last March. After that final hearing, the university entered its final order, final agency action, suspending the chapter through 2011. That hearing last March, and indeed the whole process surrounding this, was substantially flawed, woefully deficient under any applicable standard. The Student Affairs Office did not comply with Florida's applicable administrative safeguards. It did not comply with the university's own rules.
Mr. Windsor, let me ask you a factual question because I want to make sure I understand it correctly. As I understand the record, it reveals that there were only 2 live witnesses present. Is that right? And they were 2 City of Gainesville police officers who had done an investigation, and their reports were admitted through them. Is that it?
Well, that's a yes and no, Your Honor. There were 2 live witnesses, and they were both police officers. I believe one was a university police officer, and the other was the City of Gainesville.
Okay.
They both testified as to their investigation, which took place after the event, and they were present at the house after the event. The second part of your question was whether their reports were admitted through them. There actually was no documentary evidence admitted at the hearing at all.
Okay, so the reports weren't offered in evidence. No reports were offered in evidence at all.
That's correct. But
they just summarized, I guess, what their investigation revealed.
They did, Your Honor.
Including what witnesses told them.
That's right. But beyond that even, the documentary evidence was relied on, at least apparently, by the panel, and the argument that the university advances now is that that's okay, even though it wasn't admitted into evidence, because the chapter had access to the file.
And you objected, I take it, every time these officers tried to testify about what somebody who wasn't available to testify there had said to them. You objected on the grounds that was hearsay.
That's correct, Judge Webster. There were dozens of hearsay objections throughout the hearing.
Okay.
And indeed, that's one of the big issues on appeal. And I'll start with that. In addition to that sort of collection of documents that are a part of the university's file but that were not admitted into evidence at the hearing, there were some documents relied on by the panel, and this is a panel of students.
That's what I wanted to ask you procedurally. I know your first point is that you're entitled to all this panoply of APA rights and all of that sort of thing.
That's right.
But if we get right to it, this is a panel of students. Is there a chair designated?
There were 7 students on the panel, and one of them was designated as a chair. My understanding is they were all members of Greek organizations, and they're all undergraduate students. And that's so. The other 2 cases today, you had this, administrative decision below with established findings of facts and conclusions of law. This hearing and hearings like this, to the extent that this is typical of what the university would do in a situation like this, is very different than that.
But it's illegal. You don't. Well, I guess you do maybe argue in your first point that this is not a legal hearing because you don't have all the Chapter 120 rights. But this is at least an authorized hearing in this.
Well, the fact that the university's rules, the promulgated rules, provide for a student panel to determine.
That's my point, though.
Yes.
This is authorized by the university's rules that are published, the Florida Administrative Code, and that they have statutory authority to enact.
Well, Yes, Your Honor, although we would take issue with whether they have statutory authority to enact this, given the 12057 arguments that we have.
I understand that,
Okay.
and I don't mean to discount that point
No,
at
sure.
all. I want to be clear about it. But on its face, at least, the university's promulgated this rule, which sets up this interfraternity or panhellenic, whatever it's called, council consisting of students to then, in essence, conduct an administrative hearing.
That's right. And there was...
And the case law, such as it is in Florida, that addresses this issue, the 120 issue, is uniformly to the effect that you don't get all the 120 rights, isn't it?
Well, the case law is, Your Honor, to the extent it's dealing with the substantial interest of students. And there's actually a statutory exemption.
Well, this was dealing with a student organization, wasn't it?
That's right, Your Honor.
Doesn't the statute expressly purport to apply to students and student-run organizations?
No, sir. To the contrary, it applies to what it says is substantial interests of students. I've got the actual language here. This is in section 120.81.
Each state, well, in 1006.602, it says each state and university may adopt by rule a code of conduct and appropriate penalties for violations of rules by student organizations to be administered by the institution. Mm-hmm. Isn't that what we're talking about when we're talking about whether you get 120 rights or not?
I don't think so, Your Honor, because you've got you've got an issue of what the rules are, and I think that's what you're talking about, Judge Webster. But then in the separate section, there's a specific exemption as far as who gets carved out of 12057, and that deals with students and not student organizations. And so the statute that you've described would establish here are the rules, but then if there's going to be an alleged violation of that and there's going to be hearing on that, our position is 12057 would apply. And I think that is consistent with the long history of case law that suggests that when you're dealing with student disciplinary matters, due process is a flexible standard, and that you've got a lower standard there when you're dealing with students as opposed to student organizations.
Why logically would there be any difference?
Two reasons, Your Honor. The first is, the first argument would be it's clear on the face of the statute, but the practical consideration that is behind that is commanded by the numbers. The university has over 50,000 students as compared to maybe 50 approximate Greek organizations.
But there are lots of other organizations that are student-run organizations.
Sure.
Hundreds.
Sure. But not, Your Honor, the number that when you're dealing with the number of people who are applying for admission, for example, to the University of Florida. Every denial of admission would be a substantial, would affect a student's substantial interest. Every grade that's issued would be the same. Every student disciplinary matter. And it's just not workable to have full 12057 hearing.
But it would be workable to do it for every student-run organization.
Well, Your Honor, here again, it's not an everyday occurrence to remove from campus an organization that's been affiliated with the university for 100 years. And so, yes, I think that would be...
Well, you're talking about a Greek organization, but there are lots of other organizations around the country at colleges and universities that are routinely thrown off campus for one reason or another.
Sure.
Happens every day.
Absolutely. But when that does happen, it's got to be afforded due process.
But does it have to be afforded a 120 hearing?
We believe it does, Your Honor, but even if it doesn't, even if this court were to decide that this exemption applied to student organizations, or even if 12057 didn't exist at all, you've got a very serious collection of very serious due process issues and other issues where the university has violated its own rules. And what the courts have said is that when you violate your own rules as a university, then you are, per se, violating due process. And so getting back to some of the earlier questions about these documents, that was one of the critical areas, whether you look at it through 12057 or not. There was a document in the record on appeal that came to the chapter's attention only after the commencement of this appeal that was relied on by the university in not only reaching its decision, or perhaps reaching its decision, but in enhancing the punishment, certainly in reaching its decision with respect to the punishment. That document is a purported summary of the past judicial history of the fraternity, going back to 1990. And what the dean said when he more than doubled the punishment in his letter he summarized this document. And again, this document was not made available to the fraternity, and the fraternity had no notice that these types of issues were going to be...
Your argument then is not that the document is somehow worthless, but that your due process right of notice and opportunity to be heard on the document was infringed.
That's right, Judge Kahn. The chapter, had it had notice of this, could have come into the hearing armed with a response, other ways of addressing the specific allegations in that document, and they weren't given that opportunity and didn't know anything about it until it was too late. And we talked about the other document issues. Another pretty egregious issue was the ex parte communications with this Greek judicial board. You've got here the university brought the charges, an assistant dean brought the charges, signed the charge letter, met with the chapter to discuss the charges, set the hearing, and then attended the hearing and deliberated with the Greek judicial panel into the wee hours of the night. That was objected to at the hearing, and what this court has said is that when you've got due process doesn't permit having this one person be an advocate and an advisor to the board. The university says that's all she was an advisor to the board, and that would be fine if she weren't also the prosecuting authority.
Now, what is the provision that's made either in statute or rules for the board to have an advisor at all? Is there some provision?
There may be, Your Honor, but I don't recall that.
The first question I asked you had to do with just to kind of inform us about how the panel is comprised and who's on the panel. And I guess what I'm getting at is, trying to make some sense of a system where you go to court over almost everything.
Sure.
Now, and I'm envisioning this group of IFC people or whatever they are, and the best and the brightest in the University of Florida. I still don't see how they can deal with objections having to do with sophisticated evidentiary.
Well, I think and I'm not sure if this is directly answering your question, but I think you've got a difference when you're dealing with this type of sanction, as opposed to maybe a Greek panel that can handle things like this and decide about removing spirit points or affecting something else like that doesn't have the
or even just a straight factual determination.
Sure. That doesn't carry the significance of this. But to answer your question as to how the process works, the university in its answer brief sort of walked through, well, this is kind of how it works, but without any citation to authority or to, it just sort of flows the way it flows, and the university did what it wanted to do, and that's frankly not what we would hope for when you're dealing with substantial rights like this. And I see I'm eating in my rebuttal time, but one quick additional remark, and that is...
Well, before you make that
Sure.
additional remark, I have another question related to the 120 issue.
Yes, Your Honor.
Did you request that the university afford you a 12057 hearing?
There's nothing in the record.
So your argument is this is fundamental error?
Well, yes, Your Honor. They came forward and set the hearing with that, and at that time, again, the chapter wasn't sure exactly how the hearing was going to proceed, but certainly there are 12057 protections that we believe should have been
But there's
applied.
nothing in the record that demonstrates you ever requested a 12057 hearing, even after the hearing had started and you saw that it wasn't going to be a 12057.
That's correct. We objected to certain components that are part of 12057, but not specifically the... And so I'd like to reserve the remainder of my time.
All right, we'll observe that for you. Thank you.
Thank you.
Good morning. May it please the Court. Good afternoon, I suppose. My name is Sonia Rudenstein. I'm here on behalf of the University of Florida Board of Trustees. And I would like to start with that one.
Could we have your name again, please?
Yes, Sonia Rudenstein.
Have you filed a notice of appearance?
Yes, I did, Your Honor.
Okay.
Amy Haas, who wrote the brief, is out on maternity leave, so I'm filling in for her. If I could start with the 120 issue, there is a requirement under 120.569(2)A that anybody whose substantial interest may be affected by an action of an agency does request formally in writing, either by petition or...
So your position is they waived a 12057 hearing, even if they were otherwise entitled to one, by never asking for it?
Yes, Your Honor. And the notion that they had no idea what would take place until they got in the hearing room is contravened by the record. The whole purpose of the pre-hearing informational meeting, which the record indicates did take place here, is to explain to the students the process that will take place. They're told that there will be a hearing. They're asked if they want a formal hearing or an informal hearing. They are shown all of the evidence that will be submitted to the board that support the violations, and they are informed of their right to have an advisor present and all of that. So there's an extensive informational meeting. The nuts and bolts down to the nitty-gritty details are not in the regulations, but the regulations have clear procedures for how what standards will be used and how the hearing will proceed, and the purpose of that informational meeting is to make all of that clear to the students. So even at that meeting, the students didn't request the hearing, and then, as counsel has conceded, they didn't request it when they got there and saw that it wouldn't be formal. Even if one were to go to the fundamental error argument on this issue, there are no rights at stake that the other side has put in the record below that are not intertwined with those of the students. The violations were committed by the students. There are no economic rights, per se, that the university is cutting off. All of the dues come from the students, and presumably if the chapter folds, those dues will go back to the students. So there's absolutely nothing in the record that distinguishes the chapter in and of itself from the students, per se.
But there's not a decisional law indicating that exception applies to student organizations as opposed to simply students.
That's right, but I think, as Judge Webster pointed out, 1006.60 clearly it enunciates the intention of the legislature to make that provision applicable to students and student organizations. This legislation was passed in the 1980s, actually, after a lobbying effort that resulted from precisely this incident, fraternities asking for extensive due process, and the universities saying, listen, we don't have the capability to provide that for our organizations, and that was this legislation was the direct result of that.
But 1006.60 refers to a code of conduct and penalties. It doesn't refer to procedures, does it?
Yes, that's right, specifically to the code of conduct and penalties, but the procedures are put in place to enforce the code of conduct and penalties. So the notion that student organizations would be subject to that code, but then not subject to the procedures that apply to students, I think is somewhat untenable. The other issue is that
But now, there are all sorts of regulated professionals that there are separate statutory provisions relating to conduct that's required and penalties for all that sort of thing, but they're still subject to 12057.
yes, but they're not subject to student conduct codes. They're subject to other conduct codes established by the university. So the umbrella term here is student conduct code, and the economic rights at stake are significantly different for employees of a university than they are for student organizations. Really, all the organization is being deprived of here is recognition by the university. They can still exist in all other ways, and with an employer-employee situation, the economic right is the livelihood that's provided by the very body that is depriving them of their right.
Was there any evidence presented at this hearing other than hearsay evidence?
Well, Your Honor, I actually would dispute that the evidence was hearsay. I think even if you were to apply a 120 standard, and I would add that even under that standard, hearsay is allowed as long as there is other corroborative
Right,
evidence.
my question is there any of this that would qualify as not being hearsay?
Yes, Your Honor. I think the videotape statements by the pledges were
I thought the
statements
agreement
against,
was that those videotapes were not going to be considered by this panel.
Well, I think the record could be read in two ways. I think.
Well, that's the way I read it.
Okay. Well, we would read it that actually there was a discussion that happened after Ms. Crandall's comment about whether or not she meant to exclude more videos. There were other videos that the
Well, it
university...
seems to me you have an even bigger problem then with regard to hearsay if they were considered.
Well, those
You've got
statements...
do we agree you have a rule that says that these student organizations will have the right to question adverse witnesses?
Yes, Your Honor.
How do you question an adverse witness if the fact witness, is not physically present?
Well, I would give you two answers to that. The first is that that provision has never been interpreted to require that every single witness be called before the hearing.
Really? Doesn't Morfitt require that?
Well,
it's not precisely the same rule, but it's sure close.
yeah, it's close, but I do think there's a distinction, and I think there is something to be noted about how the university itself interprets it. The university has no subpoena power, so it has absolutely no right to insist that a witness come forward.
But the students have a right, as I understand all the case law in Florida on point, to require the university to follow its rules.
Well, okay, if you interpret that rule to require that every witness be brought before them,
what good is the rule
or that
otherwise?
they have a right to question those witnesses. Certainly in the case of the pledges, the Pikes themselves had all of the pledges on their witness lists. Those pledges live with Acting President Duffy. They are their compatriots. They certainly had notice of who of all the pledges were, and they indicated to the university that they would be calling all of those pledges. The university therefore opted not to do so themselves, and the Pikes didn't call them. I don't think the university can be faulted for not requiring that those students come in when the Pikes themselves enunciated an intent to call them as their own witnesses.
So your position is the record does not demonstrate that the university withdrew those exhibits?
Well, I actually don't think it matters a whole lot, Your Honor. I would say, yes, that's right. They did not withdraw them. And I would say they hold up even under the hearsay rule because they are all statements against interest made by parties who are clearly identifiable to the Pikes. Each of those pledges admitted that they had been serving alcohol to minors without checking IDs. That was a statement against interest, and it would be in a court of law admissible under the hearsay exception. So even if you want to apply the hearsay standard, the same goes true for the minor women whose statements, I would argue, certainly weren't considered by the board because they rejected the hazing charge. But even if they had been, those minors admitted that they had imbibed alcohol as served to them by the Pikes, and those were statements against interest. They're admissible under the statement against interest hearsay rule.
But you didn't argue that before the hearing board.
Well,
that
Your
issue.
Honor, it was first of all, the university, there was nobody there to represent the university. I would say that, I mean, our contention
There wasn't an
is
assistant general counsel there?
Our consent, well, okay, you're right. I'm sorry, Your Honor. I did forget about that.
Didn't that person actually participate in the deliberations?
No,
Or
she did not.
at least was present for a time in the room while they were deliberating.
Yes, Your Honor.
We can't know whether she participated because there's no record, can we?
That's right, Your Honor, but that's a very clear distinction. We don't know if she participated. And all of the cases cited by the Pikes for these ex parte communications, including Bay Bank and Trust and Love, first of all, those are all formal proceedings, courtroom-like settings, either administrative hearings under 120 or actual courtrooms. That is not this case. Secondly, in all of those cases, in Love in particular, and Bay Bank as well, the courts held there has to be an evidence of prejudice. We have to know whether or not this appearance of impartiality actually prejudiced the defendant or the aggrieved party, and there is no such evidence in this case. The Pikes had no right to record those hearings, and the fact that they were not recorded doesn't alleviate the fact that they still have to demonstrate that these so-called ex parte communications prejudiced their case. And I would argue the opposite. There were 3 charges against them, and the 3rd charge was not found by the board. So I don't know that there's a case to be made that something nefarious went on behind closed doors so that these students were somehow convinced to sanction all 3 charges, because they did not make that finding.
Going back to the hearsay business about these statements against interest, I mean, that hearsay exception applies when the declarant is unavailable.
Yes, Your Honor.
And can it be said that these declarants that it was established that these declarants were unavailable?
Well, to the extent that the Pikes themselves were to call the witnesses and then didn't.
But I mean, they don't.
Certainly.
I mean, doesn't the university have some burden of proof to carry here? I mean.
No, No, again, well, unless Your Honor wants to find that 120 is applicable, but even then.
Well, what's the point of the hearing if I mean, there's not a requirement that something be established to demonstrate a basis for this discipline that's handed out? I mean, who carries the burden here?
Well, Your Honor, absolutely. The university carries the burden of proving by a preponderance of the evidence that the charges have actually been met with evidence. But the standard for relaxed due process in a non-120 hearing is quite loose. Substantial evidence, right to be heard, and right to ask questions. So it's, it's a very loose standard. And indeed, there are cases in non-120 circumstances where all that's provided to a student is a meeting with an administrator who then decides.
But the whole thing can't be based on hearsay, can it?
Well, the whole thing wasn't based on hearsay. There were 2 live witnesses.
But these live witnesses were testifying to what other people said to them.
No, they testified to their own investigation, which
They
was
had no personal knowledge of the relevant facts at all, did they?
Well, Your Honor, I guess I would say, I guess I would see it slightly differently. If you were looking at a criminal case in which a witness said, I saw a man rob this woman. He was a white, tall man with blonde hair, and he had a big tattoo on his forehead. And the police officer then walking down the street sees a man fitting that exact description. This person is arrested, and the victim is then, her identification is then allowed into court through a statement of the officer.
You think that would be admissible? It would be admissible for the officer to repeat her statement?
Well, I just lost a case in the second DCA where they said it was. You're right.
I'd like to see that case. Well,
I think the point I'm making is that corroborative evidence can go beyond simply what is told to the officers, what is actually witnessed by the officers, and extend it to give certain reliability to the out-of-court statements, so that if the witness said, I was at the party and I saw punch over here and jello shots over here and beer over here, and this is what happened, and then the officers go and they see punch over here, beer over here, and shots over here.
Is that what happened here?
The officers saw things indicative.
They actually saw alcohol in the house.
They saw jello shots, and they saw beer taps, and they saw the semblance of a bar, and they saw enough to corroborate, I think, some of what those witnesses said to give the witness statements some indicia of reliability.
But did their observation standing alone demonstrate a violation of university policies relating to alcohol?
Yes, Your Honor, because the party was not registered, and that's the first charge, which is that the organization had a party where alcohol was served and they did not register it as required by university violations. So that in and of itself is an indisputable fact that the Pikes have never contended. They've never presented evidence to the contrary. And that alone, without any testimony, supports violation number 1.
What do they have to go notify someone at
There's an
the
email
administration
system.
building? It used to be Tiger. I don't know what's but they have to notify someone there if they're going to serve alcohol at some function.
Yeah, there's an email registration system. And so that's a verifiable fact that the Pikes did not register this party. So, I think once you get past the 120 hurdle, which is quite easy in this case, and then you look at the rules that the university has set out.
Let me read to you some language from Morfitt, because it seems to contradict everything you've been saying here. The language reads, the complaining witnesses were never called. In fact, the only statements from the alleged victims were contained in the investigation report written by an officer who talked with them. Morfitt was entitled to have the witnesses make their statements directly to the hearing officer, and he was entitled to question them. This is a fundamental ingredient of due process in any judicial or quasi-judicial proceeding. It is recognized that in school suspension cases, a relaxed due process standard is followed. However, the school's own code guaranteed Morfitt this right. Isn't that precisely what we have here?
Well, I think the language is slightly different, first, but secondly, I think the university was perfectly appropriate to rely on the witness list submitted by the Pikes and therefore not call the students to testify. I don't know that they had an obligation to second guess whether or not the Pikes, I mean, the Pikes can't benefit from having said, we're going to call these people, not call them, and then say, our due process rights have been violated by the university because they didn't call them. If they wanted to make sure they were there, they should not have put them on their witness list and should have relied on the university to call them. As to the women, again, the statements they made were against their interests. But secondly, I think just as in rape shield cases, there's a certain argument to be made that when young women are making charges of the sort that they made against these fraternities, they shouldn't have to give their names and show up because of the social pressures. And that's the way that the university has interpreted its own rule.
The rule that says they'll have the right to question adverse witnesses.
That's right, Your Honor.
So not only do you not have to bring the adverse witnesses to the hearing, you don't even have to identify them.
In this particular instance, that was the case.
Okay, thank you.
Thank you very much.
I think one of the primary problems with this case is that it's unclear exactly what did happen below, what the board did rely on, what their procedures really were. I think I understood the argument to be just now that it was not a formal hearing, but the chairman of the Greek Judicial Board said at the hearing that it was a formal hearing. He earlier said it was not a formal hearing and certain rules wouldn't apply. So I think at the initial level, when you had this group of students deciding the future of this organization, there were some problems there.
What's your response to counsel's contention about what the officers did observe in terms of the implements of having consumed alcoholic beverages and fairly strong circumstantial evidence that there was a party there?
Sure.
Not direct evidence.
I think that from the officers' testimony, they went to the house several days afterwards and they testified that they saw cups and beer taps and things like that. But if you look at the actual findings of fact that the Greek Judicial Board found, it goes way beyond this. They found violations based on a failure to ID partygoers, a failure to...
I'm looking at that, and they did make, I mean, with regard to the first charge, they did make extensive findings, and I guess part of her argument that she didn't mention is maybe some of those findings could be sustained by the officer's testimony and some could not.
I think, in fairness, I think that if the sole finding, and if you put aside all the other procedural deficiencies, if the sole finding were there had been a party within the last
there was liquor present at the party.
Yeah, I think that there's, the officers testified they were there and they saw liquor. But they couldn't testify and did not testify as to whether there was security at the party, whether armbands were being worn by visitors, how many people were there, these types of things.
But on the question of and to be honest, I don't know the significance of the committee having made multiple findings on the first charge and apparently fewer findings maybe on the other charges, but at least as to the presence of liquor and the failure to obtain an event permit, there doesn't seem to be a serious dispute of fact.
Well, there was no evidence in the record, Your Honor, regarding permitting, as far as I can see.
So there's no evidence to prove the negative as far as there not being a permit, no direct evidence.
The issue of registration wasn't even brought up at the hearing, unless I'm mistaken.
Okay, good answer.
But I see my time is not almost, or is almost up, but not up. I don't think it's fair to shift the burden to the fraternity. And as far as these ex parte communications, we will never know what happened with those. But once there's an ex parte communication, this is from the Jennings versus Dade County case that we cited in our reply brief, harm is presumed. And so here you have the prosecutor going back with the panel, and harm, I think, is presumed there. And I don't think it can be excused by saying it's unclear exactly.
Well, now, why do you characterize this particular university official as the prosecutor?
Well, there were several people there, and I apologize because my time is.
And I'm sorry, I asked the question.
No, that's fine. The assistant dean of students, and I believe I have that title right, is the one who presumably issued the charges. She certainly signed the charge letter. She met with the chapter to discuss the charges, and then was present at the hearing and made at least the one call it a ruling that was discussed earlier about the video presentation. So, the university is correct that this wasn't the type of hearing where you'd have a prosecutor, but it was so much of its own type of hearing that.
But aren't there instances under 120 where the same board that adjudicates also does the charging?
I'm sorry, could you
Aren't
say?
there instances under Chapter 120 where the same board or body that does the adjudicatory function also brings the charges?
I'm not sure. There may be. The authority we rely on says that you've got to have separate things, and that due process demands that.
Okay, thank you.
I appreciate the question.
Thank you both. That completes our